Actually, we'll go to Mr. Burlison first, then Mr. Scott.
Thank you, Mr. Chairman. Mr. Wolfson, I want to continue on that line of discussion about the transparency in that rulemaking process. So in your testimony, you said that that the Department of Labor evaded transparent rulemaking and public scrutiny for its regulatory actions. Can you elaborate how exactly did they evade that?
Yeah, there's two different ways that the Department of Labor or any federal agency can go about doing it. One is to call something guidance that's actually a regulatory change. And so you claim that you're just putting out some assistance to companies on here's how you're supposed to comply with regulations that exist. But if that guidance actually creates new obligations, then that should go through the full notice and comment process. And there was a big fight about this. President Trump signed an executive order that President Biden got rid of. The Department of Labor was required under that executive order to post all of its guidance documents online. The Wage and Hour Division hasn't posted a single document on that guidance portal in 2023.
And for anybody that might be a nerd and watching C-SPAN, the distinction between a guidance document and the rulemaking process is significant because of what has to be done to actually pass a rule or a law versus what is done in guidance, correct?
That's exactly right. So a guidance document can be written literally in 5 minutes on an email sent out to the whole world. There's no obligation that go through the Administrative Procedures Act process, and to get that struck down by a court is really challenging.
And the assumption is that these are harmless, that they're essentially creating best practices, but the actual outcome is you have state agencies who are charged with enforcing some of these guidance documents, and so it ends up becoming, in effect, law.
Absolutely. And, unfortunately, some of these guidance documents we found when we were evaluating the guidance documents at the Labor Department existed in one place and one place only. They were in hard copy in the U.S. Department of Labor's library. And so that would mean that if you're a small business in Wisconsin or in Tennessee, you'd have to send a lawyer to Washington, D.C., read through hundreds of pages of paper documents to figure out whether you are or are not in compliance with this kind of hidden set of laws.
Thank you, Mr. Wolfson. Mrs. Gretzler, is that right? In your testimony, you explained that in the proposed rulemaking for the Davis-Bacon Act, they significantly underestimated the costs to businesses, and it appears that it's because we now have new businesses that are being lumped into the Davis-Bacon Act, correct? So these are suppliers, manufacturers. So if you're building a building and the truss company, the company that makes trusses, is supplying those, they suddenly have to now comply with the rules of the Davis-Bacon Act?
Correct, and so it's including anything associated with that construction into it. And so they're saying, we know that this will drive up costs, maybe by as much as $7,300 per worker from one small component, maybe by a couple thousand for another of the 50 components. But we're not going to extrapolate that because we don't know how many workers it will affect. But they do know that already it's affecting 1.2 million workers are governed by these wage rates. So they could have at least provided an analysis to say, here's a range of how many it could affect, and they failed to do that.
And the increased cost, who pays that increased cost?
Well, the division does point out that a lot of these costs will just be passed on to the federal government, who's
to
the federal
taxpayer.
government, the taxpayers who are behind this. But it also is going to result in reduced quality of service and quantity of service because you have more money that's having to be paid when Congress has allocated a certain amount of spending. And a prior Heritage Foundation analysis has estimated that the DBA Act, as it stands today, without these increased costs, is already driving up federal construction costs by 10%.
And sadly, it benefits some areas more than others. And I come from a deeply red district where labor union prevalence is very small. And yet, and if you talk to employers, they sometimes will turn down contracts because it completely disrupts their normal business operations with their employees, throws them into situations where employees get paid dramatically more, and then what happens is those employees then take a couple months off, right?
Yeah, and this is a deterrent. Over 80% of construction companies are not unionized. 83% of construction workers aren't unionized. To have to comply with those laws is difficult, and this further.
Is it safe to say that the taxpayers get less for their money under
Exactly.
Davis-Bacon.
Yes.
They get less schools, less post offices, less roads under this.
Correct.
Thank you.